Well, please join me for the Pledge of Allegiance. Pledge allegiance to the flag
The flag of the United States of America, and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Good. That's fine. Okay. So. Before we start the meeting today, I'd like to talk about our process. The meeting is being conducted in person as well by phone and Zoom. This allows participation in person or remotely. We will conduct roll call to determine who is present. Throughout the meeting, we'll call on individual planning commissioners to make sure that everyone has a chance to be heard. Planning commissioners, please state your name prior to speaking. We would like to thank everyone for their understanding and patience. Minutes and audio recordings will be available on the Planning Commission website. So I, Hunter Newhart, call this meeting of the Crook County Planning Commission to order. Today's date is July 23rd, year 2025. The time is 4:01. People joining me are your Crook County Planning Commissioners. We are volunteers that have been appointed by the Board of County Commissioners and make up a diverse cross-section of the community. Roll call for the Planning Commissioners. We have
Hunter, before we do roll call, we have, the county clerk, Cheryl Seeley, here for, our new commissioner to swear in. So before we do roll call, if we can have our new, planning commissioners sworn in.
What would you like me to do, Cheryl?
You would, no, you would just. Turn up the recording, will pick me up, I'll bend down, how's
You can
that?
pull it out.
You can move
How many
about the
cameras
room.
do I
You
have?
can move about the room.
Hold on, I got it, I got it, thank you. All right, Kirk, if you'd raise your right hand and repeat after me. I, Kirk Jovenini,
I, Kurt Jovanini,
being first duly sworn,
being first duly sworn,
do depose and say
do depose and say
that I accept appointment
that I accept appointment
to the Crook County Planning Commission,
to the Crook County Planning Commission,
and that I do solemnly swear
and I do solemnly swear
I will obey and support
I will obey and support
the Constitution and laws of the state of Oregon
the Constitution and laws of the state of Oregon
and the laws of Crook County,
and the laws of Crook County.
and that I will perform the duties
I will perform the duties
of this office
of this office
in the manner provided by law,
in the manner provided by law,
to the best of my ability,
to the best of my ability,
so help me God.
so help me God. Thank you, Cheryl.
That. And then I need an autograph from you.
Thank you very much,
Thank
ma'am.
you very much.
Thank you, Cheryl. So now for roll call for the planning commissioners. George Ponte. Present. Marlo Dill.
Present.
Laquita Steck.
Here.
Hunter Newhart here. Kirk Giovannini.
Present.
Wes Williamson. Absent. Mike Warren. Absent. Lonnie Kurtz. Present. And Frank Hook. Absent. For the commissioners who are absent, will staff please indicate for the record which absences are excused or unexcused?
We were aware of, Les and Michael, and we had not heard back from Frank.
So is there anyone in the meeting room or participating remotely that wishes to address an item not on the agenda? If attending remotely, please enter a request to speak into the chat function. So we'll continue. There has been an amendment to the agenda for today's meeting. Item 1, final decision for the Mueller subdivision, file number 21725. 00150 PLNG will be held over until the next regular meeting, August 13th, 2025. The planning commission will consider the following agenda items. Continuation of the public hearing for deliberations only on file number 217-240-000-293 PLNG. At the July 2nd, 2025 public hearing, staff asked for a continuation to collaborate with legal counsel regarding a foundational issue. Will staff please provide an update?
Good afternoon, planning commissioners, John Isaac, the record, planning director. That issue, we're still working through it. This is not ideal, but it's gonna take some time. I think about 2 months. We can bring it back to you guys. And so my recommendation would be to continue the hearing until time and date certain, which would be, I think, September 24th, 2025 would work out best.
Are there any questions for staff?
Did you say September 24th?
I won't be here on the 24th.
Any other questions?
Yes, you.
I move that we continue this hearing for deliberations only for file number 217-24000-293 PLNG to September 24th at 4 p.m.
I'll second.
Third, so we can,
I just know you'd ask, who's in favor?
okay, so who's in favor of the motion?
Monty Kurtz, aye.
Who says aye?
Otter, aye.
George Bond, aye. Kirk, aye.
Marlo Dill, I.
So now, next, the commission will move into a work session. The written minutes will reflect the end of the meeting at video and audio will be available on the planning commission website. Ready to start the work session.
So for work session tonight, we were going to do a little bit of a recap for the planning commission as far as where we are on our work plan. And Hannah, if you want to go ahead and pull that up on the website so that we can all, so that you all know where it is and where it's available.
Oh, on the website.
Yeah, sorry.
So the work plan's not on there, but the decision. Oh, where did you put that?
I just brought it up. I'm busy talking.
Look at you. So this is our 2025 work plan. Every year in January, we have a goal setting session with the planning commission. And these are what we had set out for 2025, just giving you a 6-month update. So the work on the new projects, the cultural resources, goal 5 did go through LCDC. did pass the rule. They are still working to figure out what implementation is going to look like. We have not gotten any further direction on that. There are other county planning directors that are working on that implementation piece of it. At some point, the goal with passing that is that noticing of tribes would be for any ground disturbance. So the logistics of that is what they are trying to provide guidance for. So we're still in a holding pattern with that goal. The farm forest implementation, so again, LCDC, which is the Land Conservation Development Commission, is they're the Board of County Commissioners to DLCD's Planning Commission and Planning Staff. So they're the implementers, right? They passed the farm forest code update. The intent of that update was to codify case law. So for George and Laquita, you remember when we did the agritourism for Houston's, we had very specific criteria that we were looking for conditional uses based on case law. So what DLCD did through a rules advisory committee was put that farm impacts test into the Oregon administrative rules. That will be coming before you with a code change for our next work session, scheduled right now for the end of August. Might push it out to the 1st of September, but we really do have some updates to do. So we have been working on that. It also comes with changes to the replacement dwelling. And Marlo, I know you had asked about the replacement dwelling language. And the 3 years, and there was legislation that passed that sunsetted. And that was not part of the farm forest RAC. That was legislation that sunsetted and reinstated that 3-year clause. So there was no Measure 56 notice because it was a legislative act for that. Some other things with the replacement dwelling specifically was that construction needs to take place within a certain time frame. So where some of the replacement dwellings so this is on resource ground, that they take place in a timelier manner was the intent. So another farm forest update for resource ground was passed along with the 2024 session, I believe, is childcare facilities on resource ground. And that is not in our code currently as a use. It is listed in the OARs and the ORS. So those changes are all slated for our next work session. The agricultural and equine exempt policy, we have been working with our building department and our permit techs to better align the agricultural exemption to the Oregon revised statute, not to the Oregon structural code for that exemption. So currently there's an order in place with the county that provides direction and guidance on how we process an application for an agricultural or an equine exempt structure. That structure is exempt from building permit, structural building permit. Still requires electrical, mechanical, plumbing, if there's any additional services that are gonna be in that facility. However, the structure would not necessarily require a building permit. Depending on, it varies around county to county on how these are approved. Some counties you file for a building permit and the land use planner signs off that they're allowed to have an accessory structure. And others, it requires a site plan. So we've been working really close with our building permits and our operations manager, building team to really put together what is an agricultural exempt accessory structure and have that criteria outlined so that it matches the structural code, since the building department is the one that actually provides that exemption. So that's also on our code update. So out of our new projects, we have 2 coming forward. One, we're still in a holding pattern for. Ongoing projects, our transportation system plan, we've been working with parametrics for the last couple of years, updating our transportation system plan. We're getting ready to wrap up that portion of it. We have a public open house scheduled August 20th.
That's,
August
it's
20th.
not officially scheduled. It's
Oh,
penciled
sorry.
in August 20th, and that
Penciled.
is just for the Juniper Canyon.
Right, so with our transportation system plan, our TSP update, we should be bringing that before you in
Early September.
early September. So the update to that. And then there will be an additional, is that on there? Will you scroll down a little bit? Keep going. Okay, go back up. So along with the transportation system plan, we had a grant for a safe streets plan, safety for all. And that identifies same parametrics team. They're utilizing a lot of that same information from the transportation system plan, but their focus is safety. So they've identified like high crash segments on roads and high crash intersections, and then what are some methodologies to be put in place to potentially improve, we don't want fatal accidents. And so that is hoping to be wrapped up by the end of the year. Juniper Canyon alternate route, John, can you give an update on the Juniper Canyon alternate route, please?
Juniper Canyon alternate route is kind of morphed into something bigger than just an alternate route. We're looking at kind of a multi-pronged approach to primarily address citizens' concerns about fire danger. And so we are been investigating an alternate route that kind of hasn't been on the table before, and we just got some drone footage and we just processed that, and so that we are trying to set the hearing, the next open house for August 20th to present that information.
Okay, so policy updates, the energy code update and the Department of Defense overlay. So that was from when we set this in January, I believe, kind of had a new narrower focus. And John, I know can you give an update on that, please?
So we have our first hearing before the Board of Commissioners, it's coming Monday, and then the next one is early August, dates, but early August. So we did split off most of the energy code update. As you guys remember, we were waiting on the state's new rules, and those have been approved. I think they're effective at the beginning of the year, and so once things slow down a bit, we'll come to you guys with those draft of new energy code rules. That would be September or so, October. Coming soon.
Okay. The UGBMA, the Urban Growth Boundary Management Agreement, has hit the back burner. There has been no movement on that whatsoever. So that's definitely one. It's something that we know it needs to be looked at, and we need to have more coordination and some more, communication with the city. One thing that the city has done is speak up about their kind of master planning and their city boundaries, with their industrial lands, and then what potential allowed uses within certain distances to be able to maintain their master planning efforts and, make sure that they have their buildable lands inventory, that they need. So that urban growth boundary management agreement between the county and the city is an important document, and it is one that, has just been needing an update, and it seems to fall to the wayside. So we'll need to, we'll need to bump that up again. Title 17, or no, floodplain code update. So we did that one's done. We got the model code, it's in there, we've been applying it. It has been much easier for folks to realize, you know, what if they do. They're in the floodplain, what kind of development can they do, what kind of, elevation certification and what kind of documentation they may need. The biological opinion that came out of FEMA was in litigation at the federal level, was kicked back to the state. It is now on a break, hoping that mediation can happen between the parties. And we have not heard really how that update is going as of yet. There are some counties who had started the process of like adopting those higher FEMA asks, but most counties have backed off on that and are waiting to see what type of direction is gonna be coming out in the next probably year or so. Our Title 17 has also hit the back burner. It is something that had quite a bit of traction 2023, and just staffing levels and moving forward, that work is unfortunately was not able to be utilized at that time. It is something that we would like to keep on our ongoing projects, and as we are able to get that back moving forward. Code updates will be coming. I have the work session scheduled in August. I've got the draft of what some of those updates will be started, so we'll be continuing with that. Update application forms. Hannah, do you know if we have any updated forms? We've done a lot of work over the last few years on getting those forms updated, and they're doing pretty good. So just that's more of an as needed. Look at the next page. The farm forest reports. You have a microphone.
We're trying to keep up with that. I know we submitted through the last required submittal period. But it's been a while.
The farm forest reports are annual reports of activities that would basically utilizes resource ground. So if there's something that's been developed on farm forest ground, then we report that decision to the state. And then the state, Hillary Foote is the farm forest person at DLCD, and she puts together an annual report. Used to be biannual, so I think technically it is. She's asked for it to be annual, so by January of every year, the previous year, be submitted to her. We were trying to do quarterly to keep up on them, but looks like it'll be annual this year. So that information gets presented to the legislature. She presents it as a package and a picture of what the resource ground in Oregon, what is happening to it. So the data that we provide is if someone applies for a new non-farm dwelling or a new commercial in conjunction with farm use or something that is going to be an impact on that resource ground. If it was already approved, it's not gonna be reported, such as if we had Remington Ranch come in for a modification, that's already happened, right? So that modification it's not gonna be doubly reported. But again, it's an annual report and that deadline is January of 2026 for the 2025 data.
So is that our solar development included in those reports?
Yes, it would be. Yep. That would be, yeah, for sure. And we upload the decision along with there's an online form that you fill out, these parcels, this is the proposed use, these are the parcels that are on it. Was it, a hearing or was it an administrative decision? And then we attach the decision with that. So the state has the ability to go back and review it to see how it was approved. Yeah, for sure. Temporary hardships are, planning tech. Jennifer has been working really hard on getting all those out with our operations manager, Katrina, and Jennifer working together. They've been able to utilize the Oregon e-permitting the Acela system and do those on more of a rolling basis rather than a big chunk of time, which has been really nice for folks and being able to have more continuity and understanding their approval. You have not had any opportunity for realtor training, but it sounded like Mike wanted to get something set up soon. And, yeah.
I think there's a realtor function happening next week, the 29th, that Mike invited me to, so.
Then, processes, we are just all the time trying to figure out how we can work together and make sure that, you know, a lot of times we have so many different standards, right? You've got Crook County Fire and Rescue District has this definition in their fire statutes, and the Oregon Building Code has this definition, and the Oregon Revised Statutes has this definition, and guess what? It's all the same word, but it's different definitions. So an example of that is processing facility, right? If you're gonna have a processing facility on agricultural land, on resource ground, it means something totally different to each one of those entities, and we all need to work together to try to make sure that the applicant and that we know what each other needs so that we can provide a good path for those folks. So that's something that we do quite a bit.
Can you back up 1 minute, just out of curiosity on my part? Do you have any idea how many temporary hardship permits are funneling through every year? I mean.
Hannah's gonna look and see if she can pull that information up for you.
Okay, thanks.
Yeah. Do you have any update on the possible project of a comprehensive plan assessment?
Not that I'm ready to share at this time.
And then, you know, 6 month, the completed projects were from 2024. We have, the temporary hardships that we've already, completed that are up to date as of now. So that's really good. We got the, can you go up to the previous page real quick? The floodplain code.
Yes, and for temporary hardships, we have about 3940 that we really.
That's not a lot.
No. Oh my God, floodplain.
Yeah. We have some ongoing projects that do look like they're gonna be wrapped up by the end of the year. So as a 6 month check-in, seems like we're kind of on pace as well as we can with some of the larger applications that have taken up some time. And then if you want to do the decision list. So the decision list for new commissioners, this is the other part of our January work session and goal setting, is we go through and we review the type of decision and then how that corresponds, if it's an administrative review, if it's a planning commission review, and then for internal and for public just awareness, does it have a 12-day appeal period? Is there a notice of public hearing? Is there a notice of decision, and does it require an affidavit? So that helps keep staff on track too, as we try to remember which permits trigger which requirements through the state. But it also gives people, the public, an opportunity to see some of the work that goes on behind the scenes on applications. You can see we have quite a few administrative review process. Other conditional use permits is the first one that's a PC review or it's an administrative review. It really depends on the ask. And we do have a section in our code where the director can say, you know what, this should be in front of the planning commission. So, for instance, on our August 13th meeting, the Powell View Child Care Center, to the best of my ability, is subject to standards. However, it will be before the planning commission to review that application. So that's just, it does, the way the OAR and the ORS is structured, it has a little bit of those conditional use aspect, but it's mainly has some additional standards. Again, it's not in our code yet. We don't get very many planned unit developments, but subdivisions come before the planning commission. Non-farm partitions and non-farm dwellings, if they are in EFU 2 or 3, those are administratively done. You still have a 12-day appeal period, you still have a notice of decision, and it still gets an affidavit. The planning commission's request has been that if it is in EFU 1 post Paulina East County, then it would come before planning commission. That has generally, the exception for that would be like Riverside Ranch, where it was the unrecorded subdivision, sagebrush subdivision that still requires a non-farm dwelling application. The intent from the planning commission was that large parcels, large farm parcels going for non-farm would need to come before planning commission. Go ahead and scroll down. Some of the other ones, variance. So if it's a small variance where there's a hardship, right? You have a cliff and they need to, you know, their property line is over here, but it's a cliff and they can't meet their setbacks. And so that's something that administratively, we generally handle. If it's something larger, variance that is, may require planning commission to weigh in on that. The comp plan amendments, aggregate pits, those all come before planning commission. And then the agritourism is one that goes, it's kind of interesting how the planning commission has set that up, is that there's 3 different agritourism levels that fall in the land use realm. And they're based on the number of events. So if it's a 1 event and it meets certain criteria, administration, staff, go ahead and do that. If it's up to 6 events, we kind of give an option to planning commission if they would like to hear that. So, and then if it's 7 to 18 events, bring that to planning commission, for hearing. So that's how that spreadsheet works. And if you, want to go through and kind of look at the different types of, or just become familiar with the different types of applications that we have and what that looks like, then that's where you would find that.
Katie, wasn't there at one point another level of events that county commissioners deal with and we don't?
Correct. The social gathering and the mass gathering are kind of those one-off events, like the solar stuff that happened, right? It was a one-time event, super large people. Those go through a completely different process with heavy emphasis on emergency planning and coordination through the Board of County Commissioners. We have done like a social event, a social gathering permit. I believe it was for a rodeo, wasn't it? I think it was the NFR event down at
Oh, yeah.
the arena. Outside of their agritourism, ongoing bull riding clinics and stuff they did, they had that one time, I think it was an NFR larger event with concert. So those are not necessarily land use, they've been carved out by the state to allow for that other process. And there's pretty clear criteria and insurancing information that needs to be done on that, but this is just an option for you all to familiarize yourself with the types of applications that, and again, we'll revisit it in 6 months. Okay, I'm gonna go ahead and pull up the. So next, for Laquita and George, you guys have been through these work sessions a few times now. For our newer commissioners, I wanted to give a quick high level kind of look at land use planning in Oregon and your role within that and some resources for you all, right? So I'm gonna go ahead and go next. So we won't go through all of these for sure. But this is a presentation that was done, I think this is John Jennings and Angie's that I am going to just skip over the bits that we can skip over. So I go next. Next. Oh, look at that. They have all kinds of stuff in there. So Oregon's land use was established Senate Bill 100 1973. Tom McCall was a large architect on that and provided the opportunity for the protection of resource ground and resources in Oregon. So where you have protection for agricultural ground, you have protection for forest, you have protection for coastal lands. And the planning is really to provide opportunities for a controlled growth and implement the community values based on their comprehensive plan and to protect those resources and those ideals that they have through that comprehensive. Go next. So there's the Oregon revised statutes and the Oregon administrative rules. So the legislature issues the Oregon revised statutes, Land Conservation Development Commission, the Oregon administrative rules. So the actual wording of the state law adopted by legislature is where we get our ORS. LCDC and DLCD interpret those statutes in support of those statewide planning goals And they say, this is how you do it. The next. There's 19 goals. There's some that don't apply to us because they're specifically to the coast. But those were taken into account when they do comprehensive plans, and then they're codified in our code. So our comprehensive plan was drafted 1973, 1978, went through. I don't even know if it went through, well, yeah, it did, go through like a periodic update. However, the state said, we understand that counties are very slim on funding dollars, right? And it's a big lift to update your comprehensive plan, no matter what year it is. So cities, you're still mandated because you can grow to update your comprehensive plan and and reevaluate your communities, but counties were no longer required to by the state. So our comprehensive plan comes from the 70s. It was codified in 2003. So that's where you'll see the 2003 date a lot on those areas that have not been updated. So then our code has been updated in certain areas, and our comprehensive plan has been updated only in certain areas. So for instance, when you do a comp plan amendment for an aggregate pit, that amendment goes into the comprehensive plan in that aggregate section, but as a whole, the comprehensive plan, there are sections that have not been updated, including the wildlife area, which they tried and apparently spectacularly like blew up at the end. So which was not too awfully long ago. I want to say like 2014-ish.
I think the process started earlier than that, like in 08 or something, but then, yeah. Well,
Yeah, so we have what we have. However, could be improved, yeah, probably. In the past.
So,
Yeah,
so updating things like wildlife overlays would be a comprehensive plan amendment.
correct. And it would require multiple entities coming together to find that, and that's, they were this close. Mediating the very final aspect, and someone walked away from the table, and I don't remember. I know I've heard multiple times, but I don't remember which entity walked away from the table. So, it is, we've heard in the comprehensive plan update, we would like to do a comprehensive, like,
I can share that. So, you know, you're asked if that, update on that assessment. We are looking at, instead of, you know, a broad comprehensive plan update, but specifically focusing on goal 5 resources, which we include that wildlife overlay, include aggregate resources, cultural resources, starting with that aspect of the comprehensive plan and updating that, and then addressing the rest of it as soon as we can. But especially goal 5 resources, I think, are especially important to the people of Crook County, and the urgency to update our plan there is greater than it is in other areas. So my intention is to start with that. Okay. Soon.
What's the goal 5 for?
so goal 5 is right there, open space, scenic, historic areas and natural resources. So it really touches on, I think, what Crook County is really wants to protect. And have some more better guidance on what that looks like and how we can have that represented in our code, so that when we talk to people, we have a better basic understanding and foundation to stand to have behind us. So these are not the first 9 goals. Like I said, there's 18. Look at the next, Hannah. No, there's more than that. But like beaches and dunes, estuaries, Willamette River, those are things that don't necessarily apply to us. Goal 10 and goal 14, housing and urbanization, are really popular with legislators right now. And there will be some coming down to the county at what level. We're still working that through. So mostly it'll be probably the urban growth boundary. And, we'll see what other legislation makes it through. Next. Next. Okay, how about page 24? Yes. There, okay. So as a planning commissioner, you're the decision maker. So we have a comprehensive plan that is aligned with the goals and the revised statutes and the administrative rules codified in our code. Staff's position is to put that all together and work with the applicant. The applicant's burden of proof is to show how they meet those. And then our presentation to you all to help you understand how to interpret them and apply them. Go ahead and go next. What this comes down to is community development. Right, so what you get before you are subdivisions. Where there was no houses before, now there's gonna be houses. Where there was no development before, now there's development. How does that development look? Does it reflect what's in the comprehensive plan? Does it reflect the land use regulation? Does the property owner have the ability to have that use on their property? And if they do, how did the applicant present it did they meet their burden of proof on how they do meet that? So there's definitely a lasting impact for being a planning commissioner and the decisions you make, right? Some of the solar is slated 40 years, some other decisions don't, I mean, they're there, those subdivisions are there, the Pine Crest, right, that was at the end of Pine Crest Road.
Yeah.
That'll be a subdivision, there will be houses up there at some point, so, it is community development. In doing that, the first goal of land use is citizen involvement, right? How do we, you're the decision makers for community development. However, citizen involvement, we would love to have citizens here. Pretty slim pickings tonight. But without citizen involvement, it's hard to make balanced decisions, right? If no one comes in and provides testimony, how do we know? How are we supposed to hear? There's, so holding these hearings, making sure that they are, that the changes, I was talking about the code updates coming and the work session coming, are those code updates in line with comprehensive plan and the community development aspect of Crook County? So, some other ones, appeals. So if we have an administrative decision that we as staff put out and we get an appeal, it says, oh, you know what, that land partition you did, no, staff, you missed it, applicant, you missed it. That appeal would come to the planning commission. And then you would be holding those public hearings. So some of the big things, we have a really great planning commission. You all have amazing backgrounds, very diverse, bring a lot of independent insight into your positions. And maintaining that kind of balance and experience is something that is very appreciated, and it comes through in decisions. So keeping a balance among that is really key. Having a knowledge about the community, you all have different areas that you kind of represent, but having a broad base of being able to to know the community, being able to be fair and impartial and objective is a big part of it, right? Committed to sound planning. So. I don't even know how to say that. Again, this isn't, I wouldn't have put that in there, but, and then avoiding conflict of interest. So let's go next.
Committed to some planning, that's just, doesn't make sense, right? Does it make sense what, you know, what's going on, what somebody wants to do, or?
I'm trying to think of what Angie would have meant by that, and I think there are fundamentals of planning that you look at. One of the rules of thumb, is it noisy, stinky, dirty? Is it gonna have an impact? What does that impact look like? How can you mitigate it? What does that mitigation look like? What is it? So there's a lot to it. But really, I think being able to look at multifaceted aspects and have that play a part into, is this the best use for this area, for this land, but also balancing that with property rights, right? So is it an allowed use, right? We've just in the last month have had a public hearing, a special meeting and a work session now. So we hit the trifecta already this month. Go get a lottery ticket. So legislative, is going to be our the ordinances adopting the transportation plan, system plan, the Department of Defense, updating the comp plan, that's a legislative public hearing. Go ahead, Matt. The quasi judicial is going to be where we have very specific code. There's gonna be probably case law that informs it. And I guess, one thing that I look at, legislative that affects like the county as a whole, where quasi judicial is generally just a property owner or two. Right, so a very limited number. Okay, next. Findings of fact. This is something that I think that as a commission as a whole has really grown over the past 2 years of really kind of honing the skill of making a finding. So the criteria is, staff's job is to interpret the criteria, apply what the applicant has provided, and then provide that to you all to be able to make an informed decision. So the findings of fact have to be supported by substantial evidence in the record, right? So if it's not in the record, it's not evidence. You can hear that everybody loves white dogs, but if nobody came to the hearing and said that they love white dogs and we're getting proposed a black dog, that's how that goes. So it has to be in the record. If you want to deny or approve, there needs to be a particular finding, right? So there has to be, the applicant did not meet their burden of proof under this criteria. And that is the reason for a denial. There is not substantial evidence in the record showing that the applicant met their burden of proof to meet that criteria. And then that is what is used to defend that decision when it goes to LIPA. And part of that is that the conversation is had as well, right? So if it's not raised, if it's kind of like looked over or, you know, not necessarily addressed, that can also come back. So even having the conversations during deliberations about some of the criteria or the, like, if there's a question on any of it, just having the conversation and the deliberation on that criteria and standard can inform the finding and make the finding stronger, so that if it does go to LUBA, they can't say, oh, well, they didn't even address it. So do you have anything more to add to that?
Yeah, so as a former attorney, findings of fact are, you know, my favorite things, and they're extremely important. LUBA is limited to the record, presented to them, same with the Court of Appeals. And the decisions will be upheld if a reasonable decision maker could come to the same conclusion. So LUBA can't get inside your head. They're not, you know, gonna pour through the minutes. So the findings are extremely important to lay out what you were looking at, what you considered, what you deliberated on, and why you reached the final conclusion that you did. And so in your decisions, there is probably nothing more important than the findings of fact to show how you came to the decisions that you did. So I encourage a healthy debate up there between you guys. I encourage as much public participation as possible, so they can give you guys things to consider, you know, because you're limited to the facts that are in the record. And so the healthier the debate, the more that is represented in the findings of fact that lead to the conclusion you guys made. It just makes our decisions, it makes it easier for the Board of Commissioners, and then for LUBA and the Court of Appeals, it makes it much easier for them to understand why we landed what we did and find your decision was reasonable and therefore be upheld. So my legal career started off working for a federal judge, and was just extremely impressed with him when it came time to make a decision on the bench. You know, just out of the blue, he just lay out the findings of fact for 10 minutes on a single issue. He could just describe the findings of fact, what he was considering, what was in the record, what the law was, and then why he came to the conclusion that he did. So that's something that it's not easy to do, but I encourage you guys to try to practice that muscle as much as possible.
You look them up for him.
Say again.
You looked a lot of that stuff up for him.
The role of a really good clerk is to your judge as prepared as possible and to take none of the credit.
Okay, I have a question. So they give you a packet and there's something in there that you really don't feel comfortable. They've given you one piece of paper, one outlet. Can you ask for a second opinion? I'm kind of leaving that wide open, but like a lot of the stuff they give you, for example, something from, say, the city of Prineville that said they were in support of this, but you really didn't feel like the whole city of Prineville was in support of it. Can you say, well, could you elaborate and get a second opinion on that?
So that's a really good question. I don't think asking for a second opinion is the way to go, but that's the kind of thing that would go to it's called the weight of the evidence. And so you would say, you know, we have this, the representative, this is the city of Prineville supporting this. You know, reading through this document, I don't think this is really what it stands for. I'm looking at this document and it seems like they're talking about a different issue. And so I'm not going to consider this, or I'm not going to give this much weight when I make my decision. Does that make sense?
Who would you tell this to?
As you guys are up there, as you're going through the evidence, you know, you can say this exhibit 14 that was presented here. That's where I would bring that discussion up.
So that would be during when everyone's in here. We're all having a discussion.
Absolutely.
Oh,
Yeah.
okay,
That's
all right,
extremely important that it's when everybody's here
No,
and it gives parties a chance to rebut.
Can I share something? Which I think I hear what you're saying. You're reading through your packet at home and you have a question about something. What you should do then is call staff and say, here's my question. Let them give you why that's there. But don't do any outside research on your own, because that just muddies the water.
Right.
Is that what you were asking? Is something?
It just, I felt like the other day receiving evidence that said that the city of Prineville was in support of this, and I just felt like on that issue, that is not true. And so I felt like it was misleading to us as commissioners. And so.
So this is a really good example. This is like a hypothetical discussion we're having here. We don't want to be speaking about any particular application because the parties that are party to that application aren't present to counter it. So we're speaking hypothetically about And so the Commissioner Steck is correct that it's good to reach out to staff to kind of get more information about what that represents. But then the discussion should be on the record in the hearing about your concerns with that document or about how strong it really goes to meeting the criterion or, but that discussion should be up here as you guys are behind the bench.
Thank you for jumping in, John.
And it could be during public testimony. It could also be during deliberations. So either place, you can, but just making sure that it is on the record.
Okay, that's a very good point. So yeah, if they're bringing as part of their presentation, when there's the applicant, they're part of the testimony and they're saying that, then you guys, when you have questions, you can then bring that up to them and say, you know, you said this is from so-and-so representing Y, but it's not what it looks like to me. You can also ask them. That's an easier way to get your answer.
And so is it stepping over bounds? We're talking about something not even what, but if you say, I feel like you're misleading me. And you call them out, is that overboard? And this is the reason why?
We can probably find different ways to phrase that. But yeah, say, I don't know if I would say, I feel like you're misleading. I could say, I'm looking at this document and it doesn't read that way to me. Can you try to walk me through how you came to that conclusion? Something like that is
Okay.
a better way.
So if I feel like in the future that like what you were saying, I feel like that's my case, I can reach out to John, say, okay, how should I present this? Give me the wording. It's all good. Thank you, Macready.
It's kind of like, you don't feel like you have the whole picture. You feel like, I don't feel like I can see the whole picture here. Can you help me visualize what's going on here?
That's helpful too.
But you need to be prepared to explain your thinking and your logic based on evidence that has been presented. Not based on what you heard, say on the street. That's not evidence.
Isn't that the people we're representing?
So that's one person. But during a public hearing, they can get a big group to make their.
Fair enough. Sorry for getting.
No, these are great questions to come up and you have, good people up here to be able to work
I
through some of these
understand what you're
questions with.
Gotta be on the record.
It has to be a part of material. Again, like. If no one participates, it's really difficult then to make a fair and balanced decision because we're really getting one side. So we take what is provided through the application.
So will you take written testimony and oppose, like, you know how they had their pack, let's say someone had a packet and had different stuff. Can someone come with negatives and give you pieces of paper and then you read it as well?
That's how it's supposed to work. That's why citizen
Okay.
participation is goal number one, statewide planning goals. So you can have that happen. And since I already brought it up before, during that clerkship, just things came to me first. And so it's incredible when you read one side, you read their side of the story and you read it and you're like, yeah, these guys are trying to do the right thing. They did the right thing. And then you read that's civils, so there's two sides to every case, right? At least two. And so then you read the other side, and you read that, and it totally changes your view on everything. And so whenever possible, it would be fantastic if we have public here to participate, we have agency here to participate, and so you don't just get one side of the story because that's really never the whole story, right? And so that's something we're going to be working on in our process is to try to make sure that we get more public here. Does they make things harder for you guys because you obviously have people that are, you can't just rubber stamp and then move on with your day. You have to actually address these things. It increases the likelihood of appeal because there's more parties there, so they have more standing, and so but that's the way it's supposed to work, and that's where you get to a good decision. Sound plan.
The conflict of interest is next, so John's
I
gonna
have a
take
whole
over.
PowerPoint I put together here.
Oh, look at you. I'm gonna shut my mic off.
Is that the end of this one? Okay. All right, yeah, so we're gonna dive into conflict of interest and a few other things. This would be another one of my trademark PowerPoints. It has absolutely no design. It's put together hastily, so I put this together this afternoon, so bear with me on some of this. But so this is about impartiality in land use decisions, which I think is very important for you guys to understand as new commissioners. And so through in the 14th Amendment due process, the landmark case was Fasano. A quasi judicial process requires impartial decision makers with no pre-hearing or ex parte contacts. Kind of clarified in Newberger that the key question is whether the decision maker is actually biased, not whether ex parte contacts are heard. And so there are three main impartiality concerns. The first is conflicts of interest, the second is ex parte contacts, and the third is prejudgment bias. And the first two, basically, the road there leads to bias. That's the concern there, is that there's something here going on that prevents you from judging this application simply on what's before you. That makes sense? Slide. So conflict of interest addressed in regular ORSs, and this is for all public officials. This is for the Board of Commissioners. It's for me, it's for Hannah, it's for Katie, it's for you guys. The standards are a little bit different depending on if you're part of a board or just a regular public official. And so there are two types of conflicts. There's actual conflicts and there's potential conflicts. And so with an actual conflict, either the decision maker, a family member, or a business in which the member has a substantial interest will definitely realize a financial gain or avoid a loss. And so if you are presented with an actual conflict, you must disclose that conflict and you cannot participate. You can't participate in the discussion or the vote. There's a difference with a potential conflict. Those are where there's a chance it could result in a gain or a loss with you, your family member, or a business you're involved in. And for those, you have to disclose, but if you like, you can render a decision anyway and be unbiased. We'll get to all this stuff, then you may still participate if it's a potential conflict. I kind of repeat some of the stuff, but so disclosures must be on the record at the beginning of each hearing. And failure to disclose triggers an ethics complaint, but generally does not invalidate the land use decision. So the next is ex parte contacts, defined as oral or written communication outside the hearing regarding facts at issue, not in the presence of all parties. Disclosure on the record here is also essential, so you can give the parties, the applicant or the citizens, a chance to rebut what was discussed at the ex parte contact. And there is kind of ORS 215-422 gives away when there is ex parte contact to work through it. So contacts between staff and you guys are generally not considered ex parte contact. Trying to get facts on an application, try to understand things, those are not ex parte contacts. Discussing with staff, here's what I'm looking at. Should I approve this or deny it? And then having staff say, you should deny this. That would probably qualify as ex parte contact. Those are the kind of discussions you want. Prejudgment bias arises when a decision maker has effectively decided the outcome before hearing the evidence. The standard is pretty high. There's case law, it's usually pretty high. The standard is, did the decision maker base the decision on relevant standards and the evidence presented, or did they prejudge the result? Basically, did you come in here knowing what you were going to vote before you heard any of the application material? Actual bias must be clear and unmistakable. And here, if there's a single biased decision maker, that can lead to a remand, even if everybody else was impartial. Practical tips is disclose early and often, maintain a clear record of any outside communications you guys have. When in doubt, consult legal counsel, protect yourself in the decision-making process. Slide.
John, when you say outside communications, what do you mean?
I'm gonna get into that here in a second.
Can I just say for my own benefit, is an ex parte contact when somebody stops you on the sidewalk and wants to talk about something coming up? Is that's considered?
That's about the most classic of a case of ex parte contact you have.
Okay.
All right, so practical tips. This is what I said, the way to get through ex parte communication. And so this is in ORS 215-422 sub 3. I'm just going to read this through because this stuff is important. No decision or action of a planning commission or county governing body shall be invalid due to ex parte contact or bias resulting from ex parte contact with a member of the decision-making body if the member of the decision-making body receiving the contacts, A, places on the record the substance of any written, oral, ex parte communications concerning the decision or action, and B, has a public announcement of the content of the communication and of the party's right to rebut the substance of the communication made at the first hearing following the communication, where action will be considered or taken on the subject to which the communication related. Don't like that definition, but next slide. So here's an example of disclosure. So, Commissioner Steck, it's exactly what you mentioned. It can even be something as innocuous as, reading an editorial in the paper that was saying the planning commission should deny the, ex-developer's application for these reasons. Basically, anything that you were exposed to that involved an application that's in front of you, it needs to be disclosed, and the content of that needs to be disclosed for the rights of the parties here that are trying to get the decision made. Because if they don't have a chance to understand what you were exposed to, and then they don't have a chance to rebut it, they don't have a chance to defend it. And so an example of disclosure would be that I want to disclose that on last Thursday I was pumping gas. I had a discussion on this application with Fred outside of the public hearing. During that conversation, we discussed, Fred didn't like how big this project was, and thinks it should be, half as big as it was. So while I don't believe this conversation has biased my decision-making, I'm hereby placing this ex parte contact on the record and invite any of the parties to rebut what was discussed. And so then that we have a chance for the applicant to come up and say, I understand you heard this information, but it should not be that for X, Y, and Z. That part of the thing makes sense.
Do you need to have, can you leave it as simple as, I was talking with Fred, or do you need to have, does Fred need to be aware that their name is now on the record?
There's nothing in the statutes that says that the party to whom you have the ex parte communication with needs. The point is that he's not part of the process. And so the law doesn't care about Fred. The law doesn't care about his feelings or anything like that. The law cares about is the people that are here trying to get a permit or defend against the permit, have a chance to address what was discussed with the decision making.
But the key is to, if you get in that situation, tell Fred, come to the hearing and provide testimony, you can provide written testimony, several avenues to participate in the process.
That's a fantastic point. So should you find yourself at a gas station and someone comes up to you and tries to talk about an application, were it me, I would say, Fred, I'm really excited that you're interested in this. I'm not supposed to really have discussions about the application outside of the hearing, so the parties can be involved in this. And so, Fred, if you, and I would also mention how you're not allowed to consider anything unless it's in the hearing record. Say, Fred, if you really have these concerns, please come to the planning commission hearing. It's going to be on, September 4th. I would like to hear your opinion. The rest of the planning commissioners would like to hear your opinion. We can't even consider your opinion unless you come and say it here at the hearing. So that would be the way I would address things with Fred. There's another kind of nuance of this is you're not supposed to seek out ex parte communications. So if you're at the gas station and you see Fred and you know that he knows about, he has some background with the developer, with the type of application you're presented with, you can't say, hey, Fred, I have a hearing coming up next week. What do you think about this part of the application? You can't do that. I don't even know if you can disclose that and be okay. But so ex parte, it's unavoidable for you guys. Don't seek it out. If it happens, hopefully you guys know kind of how to address it now and what the risks are. We can talk about this as much as you guys want, but
I have one more, just one more to add to that. Sometimes we'll have a developer here or an applicant that says, oh, come see my place. I invite you all to come drive by, come look at it. This is what I propose. This is what I'm gonna do. Come by and look at it. Don't go by and look at it unless you talk to staff about it and we arrange a site visit. If you wanna have a site visit and look at a site, that's fantastic, but we have very specific things that we need to have on the record. Provide notice, make sure that there's no ex parte conversations happening on the site, that your observations are then recorded on the record, because again, we have to put it on the record. But just because applicant says, well, I do business all over the state, come see me on the coast, come see what I do on the coast. And the next time you're on the or you make, don't make a special trip to the coast, like. If you want to have staff go look at something, and bring back, like, okay, this is, we were asked to do this, we can go do this. That, this is, that type of thing. But just because the applicant invites you, that doesn't like give a free pass.
No, it's not a social, you're being a bad friend if you don't, follow an invitation. Henry, can you go up one slide real quick?
Actually, I've got a question. So what about doing things, this is George, how do I say this? Doing your own kind of research, for example, looking at a site through Google Earth or the county's GIS website, looking at aerial imagery. How does that fall?
That's a great question. So if you find yourself wanting or needing that information to be able to make a decision, reach out to staff and we'll put that together and make sure that it's in the record and everybody has a chance to see it so that there isn't one person that has information that someone else doesn't, right? So if there's something else that you're like, I really want to see what Google Earth says about this. I can pull up Google Earth and we can put that in the record and then everybody has it.
That's like with other things I've seen, that's a great way to. Like, you have your view that you're seeing of a particular project, and it's a good way to kind of convey your view to other people, but through staff. So that they can go, oh, I didn't even think about it from that perspective. Now I, without even saying anything, you have the opportunity to say, I see what somebody saw.
Yeah.
So I have harebrained ideas sometimes. One of the ideas that I have in my head that I have to walk through, how viable it is and if it would be in line with all the laws is for, big conditional use applications, to add in there as part of the application, a fee for staff to do a drone flyover of the property that would then become part of the record that the planning commission could see. Because you can't make a decision on a property, you can't really understand the property unless you see it, right? So you're a human being, you want to get on Google Earth and look at it, but that can't just be inside your head. And so I would like to find a way where planning commission can see it, bird's eye view on the ground as much as possible. The parties can see it, public can see it, and so it becomes part of the record, and so it can become part of your discussion. It's a good idea, right?
Helicopter.
It's a great idea.
Crook County helicopter.
Not a helicopter, we just need a drone.
Don't give it.
Our budget's not that big. We're, I'm trying to.
John, do you have a drone?
I don't have a drone, but we have other uses for a drone that community development could use with the drone, and we have other departments that could also be benefited by having a drone. And this is a way in my head, my harebrained idea that we could maybe help fund a drone purchase. You go back up one slide.
I'm not flying the drone.
No, and that's part of it too, is there are select staff that have
John
it.
wants to fly the drone.
I do wanna. I'm not the only one, Monty. Can you go back up?
Do you mean backwards?
Yeah. So I'm talking about ex parte contacts. This is the safe harbor though. So don't, if it happens, don't feel bad. Don't feel like you ruined everything. Don't feel like you're not able to make a decision. This is the way to get through that process. It's in statute. You follow these steps, we'll be okay. Bottom line. Okay, so now, any more discussion on ex parte? All right, now can you go down 2 slides, please? Which is
Forward.
Not over.
my outlines are like that, so it's up and down. Conflict of interest. So as you notice, the ex parte stuff is listed in 215. That is addressing land use. This is in 244, chapter 244, which is for all government officials. And so this one applies broadly, like I said, it applies to all of us. And so an appointed public official serving on a board or commission shall, A, when met with a potential conflict of interest, announce publicly the nature of the potential conflict prior to taking any action thereon in the capacity of a public official, or when met with an actual conflict of interest, announce publicly the nature of the actual conflict, and A, Except as in sub B, refrain from participating. That means recuse yourself as a public official in any discussion or debate on the issue out of which the actual conflict arises or from voting on the issue. B, if any public official's vote is necessary to meet a requirement of a minimum number of votes, aka quorum, to take official action, be eligible to vote but not participate as a public official in any discussion or debate on the issue out of which the actual conflict arises. And so as you guys remember, I, kind of pounded the table for us to expand the pro tem, so we have 2 pro tems. I don't ever want to find us in a situation where there is an actual conflict of interest and we need a vote in order to meet a quorum. Hope we never get there, so that's why it's important to have as many as possible, so if there is an actual conflict, then they can bow out and not be part of the discussion. Next slide. So if you are presented as again, if there's an actual conflict, if it's a certainty that is going to affect you or your families or your business entity's finances, you got to recuse yourself. If there's a potential conflict, then an example disclosure I would say is that I want to disclose that I have a financial interest that can potentially be affected by this application. You guys can think in your heads all kinds of businesses you could have that could potentially be affected by an application. So you would describe that, and then you would say, I can remain impartial, but wanted to make all parties aware of this potential or actual conflict of interest. Scratch out actual conflict of interest, that you would not be disclosing that. If anyone wishes to challenge my participation in this case or has concerns about my impartiality, please provide that objection now so it can be addressed on the record. So that's how you work through that. Again, these roads lead to ultimately being biased. So next slide.
So just with that, we had a planning commissioner that when a certain legal team was utilized by an applicant, it was the same legal team that they used for all of their needs, and they would disclose almost exactly what John had, and just said, we utilize the same legal firm and legal team for our family needs, and it would not, does not create impartiality, just want to have it on the record.
It's just like when, Gary, when we had the aggregate mining application. You have to disclose that he also had an aggregate mine.
Mhm.
And so there's certainty that, that potential, that's a really broad thing. When in doubt, disclose.
So if
I
you,
could see where I could run into something sometime along the line when it's been a property I've appraised, just to have to disclose that I've appraised it. Not that it will really affect my opinion or my outlook on that particular property, but need to make that statement.
Absolutely, yeah. And so you disclose it, you say you can remain impartial, and so then you that deals with the potential conflict of interest, and then it goes to the bias bar, and that is a really high bar to get in trouble with. So when in doubt, disclose.
So like, I've done a lot of work at Persona, for Persona, through their main contractor. If they're gonna build a new building and it came to planning commission and I knew there was work in there, that was probably gonna come to me. It's not, I mean, I don't care one way or the other whether I get the work or not, but you gotta bring that to the forefront ahead of time.
Yep. And then if anybody in the audience had a problem with that, that's their chance to address it. And them addressing it there then gives them a chance to then appeal that up, and if it does.
Or just bow out. And let, another,
Yeah.
yeah.
So I have a question on that. If you do decide that, I'm gonna go ahead and bow out of this one. A good rule of thumb that I've always had is that you leave the building. Like,
Totally makes sense.
no longer, in the audience or where the decision makers then can see you or things like that. Like, if you're gonna recuse yourself, has been best practice.
Don't stay up there and whisper into the ear of
Yeah,
the commissioner next to
totally
you.
understand, yeah. That's an ethical choice.
Your jobs are hard enough as it is. Our jobs are hard enough as it is. Adding something like this with a simple procedural flaw is not the direction we go.
Right.
So, reading statutes is not that much fun. It's a lot easier to see these things come to life in a real case. And so this is a pretty fun one, and it's from here close to home. This is here in Crook County. This is for that Catholic church out in Palo Butte. So,
Retreat.
yeah, it's a retreat. It was almost something else, but it's a retreat. And so this was not that main case. This was after they got their conditional use permit. And if you, I don't know how familiar you guys are with this, but they wanted to have kind of an office building as part of their original approval that would be used for basically all their property and all their business around the state. And that part of their application was denied. They tried to reframe it and come back with, what do they call it? Instead of, now they want to call it pastoral centers. They came back and this one got denied. So yeah, so this one's denied. All right, you can go to the next slide. And so I think the Catholic Church, the first sound of error that was that one of the Board of Commissioners was had a conflict of interest and was biased. And so one of the commissioners owned property 700 feet from the Catholic Church property. During the hearing, the commissioner's wife came and testified in opposition to the project. The commissioner was right there at the hearing with his wife. And when that commissioner found out that they were reapplying, basically, they came in to do the county planning director office, and as they disclosed, they expressed their surprise. I'll get back to that in a minute, to the planning director. Next slide. And so, like I said, it was disclosed in the record, and so Luba ruled there was no actual conflict of interest because the potential of it was disclosed. There was not an actual conflict of interest because there was no certainty that would lead to a monetary gain or loss, basically. Owning the property nearby without more evidence of financial impact only constituted a potential conflict of interest. And the commissioner, they said, handled it correctly by disclosing it on the record at the hearing before they participated in the discussion. So that was the safe harbor there. Next slide. And when it came to bias, the standard for bias is not that an official must be completely free of any opinion. Elected officials and appointed officials are expected to have views. The legal test is whether the official can put their personal bias aside and make a decision based on the facts and the law presented in the record. The commissioner's attendance at the hearing with his wife, who testified on her own accord, and his expression of surprise did not meet the high standard of a strong emotional commitment against the project that would be required to prove bias. Commissioner stated on the record he could be impartial, and there was no evidence to contradict that. Next slide. So key takeaways from this, as I've said over and over again, because it's extremely important, you have to distinguish between an actual conflict and a potential conflict. And just living near a potential development is not an actual conflict, it's a potential conflict as far as monetary gain, and that's managed through the disclosure, not a mandatory recusal. Next slide. Bias requires more than an opinion. The standard for proving disqualifying bias is very high. An official is not biased simply because they live nearby, have a spouse who participates in the process, or against it, or have expressed a preliminary opinion. There must be proof that they're incapable of making an impartial decision on the record. There's been other cases where there's, especially with board of commissioners, they are politicians, and so they have to take stances. And there's, I forget which case it was, but years ago, they basically came out and said, no more of this. We don't like this. This is bad. And then the hearing they disclosed, they can still make an unbiased opinion on this record. And that's what was there, and that was held up. So just because you don't like something doesn't mean you're not qualified to then make an opinion on the application. Next slide. Ex parte, curious disclosure. I keep that on the table on that too. So the commissioner's conversation with the planning director was not fatal because he put on the record any information decision maker receives outside of public hearing must be disclosed in the hearing, giving all parties an opportunity to respond to or rebut it. Next slide. The record is king. This is another one I'm pounding on the table. And so this one in particular was funny. The decisions must be based on evidence arguments presented in the record. And so part of that is the argument by the Catholic Church was that the commissioner was biased. Their description of the conversation with the planning director was much different than what was disclosed on the record, but there was that conversation wasn't in the record, right? It was a commissioner went to the planning director's office and had a discussion. there's not cameras there, that it wasn't part of the record, and then so all they had on the record was the commissioner then coming back and disclosing what happened. So try to pull it up with he. So there's a footnote of Luba's opinion. Petitioner includes the following argument in petition for review. The commissioner demonstrated a strong emotional commitment in opposition to the development by showing up in the Crook County Planning Director's office and expressing his opposition to the application. Footnote then goes, so that's in the petition for review, it's page 7. Petitioner provides no citation to the record to support the quoted contention. So we have not been able to confirm precisely what the commissioner may have said about the application at the planning director's office. Nothing that has been called to our attention supports the petitioner's contention that the county commissioner has a quote, strong emotional commitment in opposition to the development, unquote. The commissioner's disclosure at the May 6, 2009 county court hearing mentions his statements at the planning director's office and is quoted later in this opinion. So we don't know exactly what was said in my office with the former planning director. But all Luba has to look at is what goes into the record. And so the disclosure of that by the board commissioner, that's what gets in the record. That's what Luba considers. I think that's my last slide. Is there anything else? Yep. There we go. Those are the 3 big bad wolves of your guys' decision making. So conflict of interest, bias, and ex parte contact. Are there any questions about those 3 items?
If you know someone, do you need to say, I know this person, I went to 2nd grade with them or something like that? Is that something, or does it go that extreme?
Yeah, I think especially if you've known them since 2nd grade, that'd be something where, like disclose. And so you sitting up there and saying, you know, I've known Fred since 2nd grade. You can even say we're friends. We went to high school together. We were on the same football team. But I'm still able to render an unbiased opinion on this application, and they give parties a chance to
What
rebut or
if you
challenge.
know, say, a person that was like the other day, what do you call him? The guy that goes out and looks at all the stuff,
Survey.
Kelso, you know,
Yeah.
I've known him my whole life. What do I need to say? Hey, I've known him. His dad was my teacher, you know, how, you know, cause like, I know everybody pretty much.
So the question whether or not you need to, that depends, right? So if there's a party in the crowd that's in opposition to that, that's opposition to the application, and you don't disclose it, yeah, they can pull that card later for
Right,
sure,
right,
as a way to get the answer they want, to the decision that they want. But I wouldn't say you needed to, in that situation, yeah, you probably need to.
And we've never done any business together or anything like that, you know, like he grew up here, I grew up here, we've known each other. Like I said, his dad was my 6th grade teacher, you know.
Yeah.
So
This is a small community.
it used
And
to be
so-
really small, you
yeah.
know.
But yeah, I mean, our board of commissioners are good at disclosing that kind of stuff. You guys are as well, but so yeah, I'm gonna pound the table, disclose.
Okay.
If you think it could influence, and if you think it could give the appearance of influencing your decision, disclose it.
Okay.
The appearance of, and so that's people's perspective, and that can be different than, in your head, you can be totally clear. I mean, I've known this guy forever, but I'm just gonna judge this application. Some of the crowd might feel different, especially if you guys give a decision they don't like. They're gonna be searching for, how can I find a way to get this overturned? How can I find a way to stop this? Correct.
Yeah.
Even in high school, that guy, they played football together. He's just
Yeah,
doing him a
I
favor.
remember I was at school with him. I know, yeah, exactly. Got you. Okay, thank you.
That's all I have. Do we want to do, we did get, June report. Do you want to cover that? Do you want to switch gears and cover that, or do we want to wrap?
I wanna just say I handed out speaker 1-pager again, when Commissioner Hermark was planning commissioner, she brought this in. It gives a good kind of just a glance. What do you need a motion for? How do you say it? And it's just those parliamentary procedures at a glance. Did you get one, George?
It did not.
There you go, George.
All right.
An extra?
I got, we got one.
That one, okay, great.
You definitely, yeah.
Oh, perfect.
So those are just some tips for you, just to kind of help you get through it.
Appreciate it.
And like. I'm disclosing something, but I called Katie and asked her a question the other day. Do I need to tell John about that for on the record? You know, I don't wanna get in trouble. I asked her information on, Katie, I really don't like something. What is the burden of proof to show that you deny an application? What does it take? Basically, it's kind of the question I asked her.
So you talk to staff, right, and that's good. And providing information that if we had a discussion about something and felt that it was something that was important for the commission to know, or that everyone be on the same page and have the same information, we'd have a different conversation, but I'll let John address that as well.
Yeah, so as I mentioned earlier, there's a carve out for discussions with staff, so that's not ex parte contact unless you are, basically, should I deny this, that kind of thing, if it's getting you, beyond the facts, beyond your role, beyond, how to render a decision, then it can get into murky territory. But talking to Katie about process and how you're supposed to look at things, that's a different discussion, that does not qualify as ex parte.
And in doing that, I have no idea disclosed that what I'm doing as far as making a decision the proper way, so I'm asking for help so that I don't cause conflict down the road, basically, doing the right thing is why I call. And that's your job, right?
Yeah.
Okay.
Yeah. Yeah,
Part of-
it's- part of it is to make sure that you all have the information that you need to be able to make the decision.
Okay,
And then if you and I have a conversation and you start asking for things that are not in the record, or asking for things for further clarification, we're gonna have a different conversation
gotcha.
about what does that mean? What does that look like? How is it something that needs to be in the record? How do we get that in the record? There's a lot of different conversation rather than this is the general procedure, right? You have the criteria, you have the record, you need to make a finding.
Yeah.
And then that finding supports your decision, and the conditions of approval are representative of that decision.
And that's what you told me.
And, your disclosure now is worthless, Kurt. There's no application in front of us, so
Oh, dang.
it's only, do when it matters.
Okay.
All right, so we're gonna move on. You guys, if you have any questions, we can continue discussing that, but so we did get the numbers for June. I'll just run these by you guys before, we're gonna present it for the board commissioners at work session next week, but so. Numbers for June on the building side, as I told you, we're busy. Building side is busy, we're down some staff, but in this June of 2025, 164 permits. Year to date is also up, fiscal year to date is also up. Kind of on a big picture, we are on everything, we're kind of between fiscal year 22 and 23 and last year, so. Busier than last year, but not as busy as kind of those peak boom years, just after COVID.
Seems like an oddity.
The things, but yeah, with interest rates so high, I don't know, I think maybe people are just tired of sitting on the
Put the
sidelines.
blinders on and
Yeah,
going.
maybe they think that if I were a developer, I would think that, the Fed can't keep interest rates up high for so long, and so eventually got to bring it back down, or the economy's gonna bust, and so I'm gonna get the things in place for my project, so I'll be ready for it when things switch. I don't know. That's a risk that be very risky. I don't know if I would take that if I was a developer. But I don't think, I'm not a developer, so I don't think like that. You can keep scrolling down and get out to the planning side, and so. 43 applications in June, 185. Yeah, there was a ton. I was on the phone today, and I was scrolling through, I'm like, wow, we got a lot, because we just got caught up. We got caught up, we felt so good. It seemed like it,
We were
relative
close.
to when I. Yeah,
So
so,
close.
and we jinxed it, I guess. But yeah, I've been busy, so 43 this June compared to 33 last June, 182 year to date, compared to just 151 last year. And then fiscal year, again, we're just up. There's one thing that's down, I'll get to that in a second, I was surprised when I saw this. So you guys are very familiar with the notable land use applications that we're dealing with. So it was August 12th was the date that we will be done with the DOT military overlay, and our grant obligations as far as that's concerned.
What is the, what is the military overlay? Like, what does that have to do with? Like the county and the planning commission and like,
So it's important that, no surprises was one of, predecessors' big catchphrase, right? And so, a party you don't want to surprise is the military flying jets, right? They don't want to see, oh, there's this giant thing here that's not supposed to be here. And so we got the grant to, kind of the thrust and the focus of it was to identify which types of development would be a bad surprise for the military, and then to implement notification procedures. So if we get this application, this falls on the category that could impact the military. So they just need to reach out to the Department of Defense to make sure they're all on board. And so the process we did that through was adding the overlay to our maps, so we know which areas are of concern, changing our code so we knew which types of applications would trigger that notification requirement, and then going through the process to amend our comprehensive plan. So some of the commissioners up here went through multiple work sessions on this, and it really didn't take that much time once we got going. But we're in the final stages now. You guys already did your process. Like I said, we're doing that before the Board of Commissioners on Monday. They already had a work session on it a couple of weeks ago. And so we got some calls from the public today since notice went out that were concerned about it. It sounds like it's a new thing, right? And so they were saying, oh, we don't want these airplanes flying over our house. It's the same routes they've been flying on for decades, but it's just now we're putting it in here and getting the notification requirements, just to make sure that there are no surprises moving forward.
gotcha,
And it wasn't great, I mean, the whole stuff.
Really?
right, yeah.
Can I,
What's better than email?
Me, not me.
can I ask a question?
Of course.
Commercial permits, just because I'm both nosy. What's being built out there west of Facebook? Close to,
It's another data center.
and more, is it more Facebook?
No, this one is, I'm glad you brought that up, actually. So this is, I can never remember their name. Opidin, right? That's how you pronounce it? Yeah, it's the Opidin data center. It's not gonna be as big as the Facebook stuff, but the contractor, the one that's developing it, they're like a big outfit that works nationwide. And they were so impressed with our building staff that they wrote me an email saying this is like the best staff they've ever worked with, and how organized they were and what a great job they did. And so I shared that with Board of Commissioners. We'll share it with you guys now too.
Because we've been working for Facebook or with Facebook so many years.
Exactly, yeah, no, we're a small county, but very sophisticated when it comes to data centers,
Yeah.
especially on the building side. So that felt good. I didn't get to take obviously any credit for that, because it had nothing to do with it, but it was just good to see that our staff is so well respected, especially with sophisticated parties that know the difference. You know, some local people, they might complain, but they don't know the difference. They have no frame of reference, right? Go to another county, it'll be a lot worse. And so it was a great reflection on the professionalism and quality of our staff. So, thank you for bringing that up, so I got a chance to brag about it. All right, let's scroll down. It's good to see, scroll up just a tiny bit. Never mind, sorry, take that back, go back down. Yeah, so onsite is good. We had been in kind of a lull with onsite this year so far, but they had a busy last month. He's also helping out with a few other jurisdictions that need help, but so our numbers are now back up over month, up year to date, up fiscal year to date on that side of things. But now, not only get to, I was surprised by this one. So again, we're above last year, but not here for it. Lewis only opened 2 code compliance cases last month.
Wow.
See you asleep.
I don't know. I don't know what happened. He usually does a lot more than that.
All the ones from the month before.
Yeah, but he's done a good job closing a lot of open cases, which is really good, but yeah, 2 new cases for June. I think a lot of that maybe has to do with a frequent code compliance site not really operating at the moment, but Yeah, numbers were down there, but that is our update for June.
He has a job that is a no-win job.
He does get.
He has a
Yeah,
very hard
I mean,
job,
like, he's got a tough job, like.
very hard job.
His-
And I explain that to people when they, 'cause some of us have to field complaints because nobody likes the code compliance guy coming to the
Right.
property, right? And so when I have to explain to them, like I would be terrible at his job, just miserable.
Oh, yeah.
But he's the nicest guy in the world. He has such a hard job. He does it so well. You kind of explain that to people like, yeah, I guess you're right. He's just doing his job. He was nice about it. All right, I'm okay with this.
Yeah,
But I'm super grateful to have him. I know that
it could be worse.
Who is it, Randy
Oh,
Davis,
vice
or
versa.
who are we talking about?
no, Randy Davis started there. Lewis Seals is our code. He's the county's only code compliance officer.
Oh, okay, okay.
He has a big job and a hard job.
Takes a lot of crap.
Takes just tons of crap.
Lewis is his first name?
Yeah,
He lives out in Bellevue, maybe.
yeah. But he, was busy in June closing cases instead of opening new ones. So
That's great.
that is a good thing, actually. Maybe a lot of it too is people were busy outside having fun and not looking over their fence complaining about their neighbors. But
Yeah.
it is what it is. So as I said, overall up, busy, except for Lewis. That is,
He was busy.
he was
closing.
busy. He was busy closing, not open. But that's our June update and our fiscal year 125 update. I think at this point I do have nothing.
So when we had talked about at one of our previous meetings about when the appropriate time is to discuss things that we went through. How do you approach that, or how do you bring that to the table? As far as like, how to. Where's the indicator for planning or building department? For when they should get into the mix, or, I don't know if it's the right time to discuss it because it's not closed yet. But it's more of a, like, over
So that's,
umbrella thing.
so I would say that as you're going through an application and you're looking at the criteria and the burden of proof is on the applicant to show how they meet that criteria. Sometimes applicants say, we will meet that criteria. So then there's a timing mechanism and an enforcement aspect to that. Or there's a plan in place that they have to meet, right? They have to meet these level of expectations. So as you're going through the application and as you're going through the record and you come across those criteria or those findings that are going to require that, a lot of times as staff, we include that in the conditions of approval, right? So we'll include that time reference prior to the issuance of building permits, prior to the issuance of a certificate of occupancy, prior to something. When you have a question on how that timing or mechanism is worded or in place, or should it be, that's a great time to give staff a heads up, right? So that we can kind of start thinking about it on our end. And bring it up to the commission and be like, okay, this criteria says that they're gonna submit a report annually. Okay, well, what is clear and objective about that? Clear and objective is the golden standard. That's what we want in all of our findings, our clear and objective findings. So what would make that clear and objective? A date and time by January 31st yearly, applicant will submit whatever that they needed to right there, right? So if you have a question on a standard or a condition of approval, good during deliberations. Sometimes they've even asked the applicant, would you be willing to do this before? And then and it's on the record, you have the applicant's response. take that into consideration and put that into the decision. Does that answer your question? Like, it sounds like you have specific questions about different timings.
You've got you said there was no indicator in the past or currently about like when that land gets cleared for a particular thing that they know they're gonna do, or they're gonna apply to do, right?
So there's a couple of different things, right? So if you're going through the material and you see things that are vague or read things that are vague, and we are always gonna run into uniqueness, right? Like I said, we've had 50 years of land use, 50 years of protecting resource ground. The ground that we have is most likely gonna have issues, right? Those ones that we're able to sail through are far and few between. So most of the time, there's gonna be other things come up with it. So if you have a question on that, that flagging would be a good spot. Are we gonna run into things where we haven't had that before and we haven't had that exact thing? Yes, and that's another reason why we do code updates, right? We realize that this doesn't work like this. So now we need to be able to, it's kind of like the disclaimers on the back of shampoo bottles, don't drink it. Somebody drank it and now we have a disclaimer.
Right.
So.
Yeah.
it-
I mean,
If,
it's like-
and if
I
you
guess what I
have
was trying to say
specific
is,
ideas, then that's something that like we can talk about.
like, it's one thing for a farmer, for example, we've got lots of Mount Palview, they dig a fresh new pond and there's a mountain of dirt, right? That mountain of dirt doesn't have any impact on anybody other than visually, right? It's just there and they'll get rid of it.
Maybe.
Or maybe they won't, maybe it'll just stay there, right? But that's a different situation than somebody cutting into the side of a hill in a rural residential neighborhood than potentially causing a safety hazard. And they're allowed to do that with no
So,
approval or anything.
so Crook County is a complainant-based county, right? If we all went around and kept a notebook, that's all we would do,
Sure.
right? So if it is a fire, life, health, safety aspect, it is something that does rise to the level.
Okay.
I will assure you that people call for all kinds of things. And we do have an amazing code compliance officer who often doesn't have to go through the full steps because we can get there before, right?
Yeah.
So there are, I think I hear what you're saying. If there is a proposed use on a property and at what stage does development trigger that?
Yes,
Right, and that was, that's what I think I hear you saying. So that is something that I think as staff, we can look at and look at our definitions. And we'll look through our code and see if we can get you an answer.
okay.
And bring
And I'm not trying to like put the pressure on any one thing, but like, we
No.
just went through this.
Yep.
The fire.
And again,
mountains of-
that's why the disclaimers on the shampoo bottle, right? So we're going forward and that's something that as staff, we're working because there's multiple entities involved, right? When you're talking fire, life, health, safety, whatever that is, right? Wildfire, house fire, landslide, whatever might happen. And we get a lot of phone calls like, what's going on this piece of property? My neighbor's doing something over there. And then we have a fantastic conversation and find out, okay, is this something that rises to that level?
I'll just add, there's a tension in Oregon law, obviously with, we want to be very prescriptive about land use and what you can do on the land and how we plan and what we're gonna do. But But at the same time, we want to make sure that agricultural producers have freedom. They don't have to jump through a lot of bureaucratic loopholes and apply for permits for this and that. And so there's that tension that agriculture, a lot of freedom, but then other types of industry or anything that they don't. And so it's hard to reconcile that, especially when the lines get blurry. So that's something we face often and
Gotcha.
part of our process to sort that out. So.
So I think, just a couple weeks ago, we were wanting to change some verbiage for future possible solar farms. Like, clearing and grading, is that something
We have some code updates that'll be coming before you guys in August that will include some definitions. One of our staff members has been making a list. And there's gonna be lots of definitions, and then if you all have something very specifically that you want to have included or have staff to look at, you know, feel free to let me know. I believe that term is on my list. I don't know if it's going to have. I don't know if it's gonna make this round or what that will look like, but that is one of the things that we're looking at.
And I also, so we were talking, or I guess you mentioned, coming up, we might have to talk about Juniper Canyon alternate route. It might be a good time for the drone to kind of show a path of maybe possibility.
So, for this, we had to, other road department had to call in a favor from a friend in a different county to borrow their drone to get this part of things done. So, yeah, that was, and we weren't in control of the process, right? And so my preference would have been to have this Juniper Canyon hearing a month or two ago, but we were at the mercy of this friend doing us a solid, getting us this data, and so that has taken probably 3 months now, at least, maybe 2 months, I don't know, it's taken a long time to get this information because we don't have our own drone. So, it's gonna be part of my sales pitch to any higher ups that I need to convince that getting this drone is a good idea.
Sheriff's Department have drone?
They do. But they need it for different reasons. You know, and it's their staff. Their staff are very busy and I don't want to pull deputies over to do one of my land use things. And so airbrain or not, you know, I wouldn't be surprised if there's a drone in community development departments building at some point here.
Any more questions? No? Okay.
Is there anything as we are here to kind of keep you guys informed and doing your job the best you can? Is there anything else that you would want staff to kind of bring to your, you know, today we did conflicts of interest and as well as planning commissioners? Like, is there anything else we can bring to you guys in a presentation that you feel like you need more information on to do your job better?
What happens if we can't make it? What's the change? You would call, say, hey, we can't be here, call Hannah, say, hey, we're not gonna make it. Email, yeah. Okay,
Sends out doodle polls occasionally to find out what people's plans are the upcoming months.
But if you have any changes after that, let me
It's a shame we can't use it. Then it's not
They're not
three
the best
people
tool.
making the biggest squeaks, or 5 over here, or whatever. It's like you get a little broader, you know, feedback, because people generally don't, like, they don't want to be on this, like.
They don't want to be on camera, they
Yeah.
can't get off work at 9 AM to
Right.
come be heard.
Lots of reasons, but
Yeah,
yeah.
but I think we're noodling how to make it easier for people to get involved in these and your guys' hearings. With an informed opinion, right?
Right.
You don't want them showing up and,
Just being whatever they heard from their neighbor.
exactly.
Right, which is the hardest part for just about anything in the community.
We got Roger.
Well, the written minutes will reflect the end of the meeting at 5:59 PM. Video and audio will be available on the planning commission website. We'll call for a motion to end the meeting
So moved.
Second.
and we call for a vote.
Monty,
I
Hunter, I.
George, I.
Okay.
We'll accept, the electronic error.
Regardless of how she votes.
Yeah.
Did you say Anders or Anderson?